Namaskar, hello and welcome viewers. You're watching the special presentation of Sansad TV, Bills and Acts, where we analyze bills that impact you, acts that empower you, and programs that matter to you. I'm your host KRITI MISHRA, and today the spotlight is on the Family Court laws. Recently, the Family Courts Act was amended. Before the detailed analysis, let's take a look at the highlights. Family Courts Act 1984 allows state governments to establish family courts. The Amendment Bill of 2022 seeks to extend the application of the Act to the states of Himachal Pradesh and Nagaland. Family courts are established to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs. Well, it is known that family courts have been in existence for several decades in countries like Britain, Japan, and Australia. The movement to establish family courts in India was initiated around 1958 by Durga Bhai Deshmukh, the noted social worker from Maharashtra. From the beginning, the objective of establishing these courts was to provide speedy disposal of cases involving problems faced by women who were traumatized by marriages that had turned bitter. Family courts have been set up to deal with problems that arise on the breakdown of a marriage, divorce, restitution of conjugal rights, claims for alimony and maintenance and custody of children. The setting up of family courts does not in any way alter the substantive law relating to marriage. And for deeper understanding, I'm joined by an illustrious panel of guests. Joining us in the studio, Mr. P. Wilson, Member Parliament of the Upper House and Senior Advocate, Supreme Court. Also joining us, Dr. VAGESHWARI DESWAL, Professor, Faculty of Law, University of Delhi. And joining us through virtual platform, LALITHA KUMARAMANGALAM ji, former Chairperson, National Commission for Women. Also joining us in the studio, young and vibrant audience. I welcome all of you on Sansad TV and thank you so much for joining us. And Mr. Wilson, let me begin the program with you. You may recall when this bill was getting passed in Parliament, the government assured that it is ready to provide the necessary infrastructure to the state governments and to the high courts for establishing family courts. Given the fact that more than 11 lakh cases are pending across 700 family courts across the country, in that context, how do you take the importance of the Parent Act and the Amendment Bill?
The Amendment Bill has come in a peculiar situation where when the Family Courts Act came into force in the year 1984, 24 states were notified about coming into force of this Family Courts Act in the year 1984 and thereafter. 2 states, namely Himachal Pradesh and Nagaland, this Family Courts was not notified under Section 1. What happened is the state of Himachal Pradesh, they established courts. The state government in consultation with the High Court have to establish family courts in each districts according to the population that is set out in the Act. They have established in the year 2019, so far as the state of Himachal Pradesh is concerned. Likewise, in state of Nagaland, they have established courts in the year 2008. Unfortunately, in these 2 states, the central government has not notified that the Act has come into force. So what happened is, the courts that were established were hearing the matters without any jurisdictions. Divorce were passed, alimony were fixed, maintenance were fixed, custody of the child was granted, property disputes were settled, and ultimately one fine day when a litigant moved the High Court saying that the Family Court has not been notified by the central government as required under Section 1, then only the entire government realizes that there is a lacuna in bringing a notification in accordance with the Act. Therefore, the Parliament was immediately, the government moved the Parliament. They brought this bill. It's like a legal emergency. They have to, validate all the acts that has been performed by the courts, which was found to be illegal and void because of, not notifying it. Right. And both the houses have uniformly allowed this bill for a safe passage, and that's how this bill came into force. I would say that the right move of the government, because there is a lacuna or there is a fault on the part of the bureaucrats in not notifying it on time as required under the Act. And that is how the Parliament has rightly stepped in and understood the problems and have clearly notified retrospectively, right from the day when the family courts were opened, insofar as the state of Himachal Pradesh as well as in Nagaland, 2019 and 2008 respectively. And all acts, all degrees, everything has been validated under the amendment bill.
Absolutely. So that was the significance of the Amendment Bill of 2022. But I'll get back to the Parent Act. Lalitha ji, the Act provides that persons who are appointed to the family courts should be committed to the need of protecting and preserving the institution of marriage and to promote the settlement of disputes by conciliation and counselling. Now, I'm just recalled by one of the observations of the Kerala High Court. It recently made some observations about marriage and its sanctity in today's society. The court observed that the trend seems to break the nuptial tie on flimsy or selfish reasons. In this changed socio-economic milieu, how do you see the importance of the Act?
Look, the Act per se is not a bad Act at all. It's actually a very well thought out Act. The problem is not the Act. The problem lies in the way people think of women in this country. Marriage is undoubtedly one of the institutions that upholds society. But unfortunately, marriage also in itself implicitly implies that the respect of women should be maintained in a marriage. Yes. Most marriages today are breaking up because, partners don't get along for various reasons, one of which is violence against women. Yes. On the other hand, there is also the ego problems between earning women and their earning husbands. As you know, nowadays, young girls who are educated are not willing to compromise as much as perhaps women of an earlier generation were taught to do or expected to do.
Perhaps.
The expectations for marriage today are different. So I think judges in family courts also sometimes have a very tough time. I'm not saying they all have patriarchal attitudes, but often the continuing patriarchy in the social system, especially where marriages are concerned, where the woman is generally, and I'm saying generally, I'm not saying it always happens, it is increasingly decreasing. Now that sounds almost like an oxymoron. It is actually decreasing. Expectations that women will play the subservient role in a marriage. But even now, often partners are expected to compromise in ways in which they are not willing to do so. So you will find that the demand for the applications for divorce, etc., have increased an enormous amount. Just recently, a very, very good friend of my elder daughter's, who happens to be a lawyer and whose wife also happens to be a lawyer, they have had a very amicable separation. Now, both of them being lawyers, they understood the implications for both their child and each other. But the problem is that these are young, educated, upwardly mobile, urban girls and women and men. But very often you find that divorce is something that both individuals, husband and wife, more wife perhaps, but equally sometimes husbands, apply for when they have reached a point of no return. And while the court's job is definitely to try and see if a reconciliation can be effected, not only for the sake of the children, but for the sake of the husband and wife too, sometimes the marriage is irretrievably broken. And in that case, the court's job is to see that there is an equal and impartial separation of assets, etc., and to minimize any deleterious or unfortunately negative effect it may have on children. Now, in that sense, I don't think the Act per se is a bad Act at all. The way it is applied depends, I suppose, from one family court to another, depending on the judges, depending on the lawyers, many things. I have heard many complaints about lawyers being quite unscrupulous, especially when one partner is not as educated about the law as the other is. But I don't think the Act per se is a bad Act. It's actually a pretty good Act. It was thought out in great detail. Initially, when Durgabai Deshmukh ji, the very famous freedom fighter and social worker from Maharashtra, she asked for this because she saw the amount of women who were suffering. One of the biggest, let me say, achievements of the Act is that when polygamy is practiced, and it's not just practiced amongst one particular community.
Absolutely.
Let me tell you, there are many men from many communities who supposedly have more than one wife, which actually is illegal because legally only one wife is allowed, is permitted. The ill effects of polygamy were felt by many women throughout India, throughout centuries. It's not just India, I think all over the world perhaps. In order to get rid of that, and in order to see that women have a more equitable access to the assets in a marriage, including income from both sides, or one of the single, if one of the partners is the only one who is earning, and to see that children, don't get caught in the friction between families or between spouses. She suggested this act, and I mean, she was a brilliant woman, apart from being just an extraordinary woman. It was good that the government of that time understood the wisdom of her request, and that the Family Act actually was brought in.
Right, ma'am. Ma'am, you made very, very important points there. I'd like to take one by one. First, let's focus on domestic violence. How effective has been this act in ensuring that there's no domestic violence? Of course, no domestic violence would be an ideal utopian situation, but I'd like to understand the impact on the ground.
See, domestic violence is something which is covered not under the Family Courts Act. These go to the magistrates' court. But domestic violence, by and large, family courts, since they have provided us a non-formal sort of a forum in which we don't need to engage lawyers, parties, they can go, and we try to resolve their disputes amicably. Wherein mediation and conciliations, these are the preferred modes of settlements. So when we are providing the parties an easy solution, not only an easy exit point, but an amicable exit to the relationship if the ties are strained between them. So in a way, instead of going to the magistrate and talking about domestic violence, if they want any solutions, they can easily approach the Family Courts Act. But yes, if we talk about Section 498A, which is cruelty against a married woman, now that is something which intersects criminal law as well as they are the issues when we talk about divorce. Invariably, there are cases where the women's side, they slap 498A on the boys' side.
True.
So definitely in family courts, when there is a conciliation or there is an effort at settlement of the issues, whether they themselves go for it or whether it is a court-mediated settlement. In either of the cases, if there is a settlement, definitely they have an option. They can go and get the courts to exercise their inherent powers and quash the criminal proceedings also. So in that way, I believe that this is a very good step.
All right, Mr. Wilson, before I take a few questions from our audience, one of the concerns repeatedly being raised that the judges who are appointed to these family courts, do they have the required expertise?
You are right. Normally, there is no special or specific appointment to this judges of family court. The district judges, the requirement under the Act is that they should have experience as that of a district judge. So time has come where, these judges who are given with the family court's work should be suitably trained, or some amendment should come in insofar as the Family Courts Act is concerned, so that they are very much accustomed to all these family problems. Of course, as a human being and as a married person, they will really understand, but you need some more, the different situation, so different training where, to approach these types of cases. So therefore, I think as a lawyer, as a senior advocate, that time has come where, you have to post judges with good training, and periodical, workshops should be conducted to them, so that they can bring in what the entire intention of the Act is, to bring a good conciliation and settlement of the disputes. That's what the Act says. The real intention of this 1984, of course, I would say it's a complete code, where their intention is to settle the matters amicably. So therefore, these judges should not see these matters within a narrow scope of settling a case or going under a act where the prayer restrict themselves with regard to the prayer. They have to work more than what is sought for in the prayer. So when they go into the intention or object and reasons of this Act, certainly these judges should be sensitized about the real scope of the object of the Act, so that they bring in a harmony within the families, try to settle this matter amicably, a conciliation process, and ultimately, if it is not possible, then they can go for a divorce and other things. So time has come where you need specially trained judges, particularly judges who also know about the gender justice also, the gender justice. So that is very important in these types of cases.
Absolutely, sir. You talked about sensitizing the judges. I'll take that to Lalitha ji quickly. Lalitha ji, for instance, when a woman files for divorce and maintenance, the husband turns around and presses for reconciliation only to avoid paying maintenance. It is crucial to the women that people who are mediating are aware of these strategies. If a judge or a counselor feels that a woman should go back to the husband simply because he's making the offer, and as a wife, it is her duty to obey him, it will be detrimental to the women's interest.
Well, let's say one thing, that it's unfair to always put all the blame always on the men. There are also many cases where, women sometimes apply for fairly flimsy reasons because they feel that their voice is not being heard in a marriage, in which case reconciliation and, very importantly, counseling is necessary. I think family court judges should also be, and I think this will require an amendment in the Act, should be able to consult experts in this field. It's not easy for a judge to become a gender expert or to understand the ramifications of how and why and where marriages can go wrong and come to a point of, come to the breaking point. So, and they deal with so many cases. I mean, there's a huge pendency because the number of courts is just not enough. The number of divorces, separations, etc., conflicts in a marriage have gone up to such a huge degree, I think by several 100% over the last 30, 40 years.
Right.
That I think judges not just need training, they also need facilitation to a certain degree.
Absolutely.
And a marriage is not an open and shut case like a crime, where if there's proof, then it's either yes or no. There are so many gray areas in human relationships, especially marriage, that I don't think you can always blame the judges for being non-sympathetic to women or empathetic to women. But yes, I think lawyers also need to be gender trained in this case. Mr. Wilson has an extraordinarily good reputation when it comes to his work in this field. But too many lawyers, unfortunately, they don't look at the relationship. They don't have an empathy. It's like they're just dealing with the case and you have to get it done. You have to come to some sort of a conclusion as soon as possible and get the whole thing done. Maybe in some cases that's all right, but in many cases, an understanding, between the lawyers of the two different sides, a little more humane approach, which is not just very clinical about yes or no. As you know, all human relationships have so many gray areas. So I'd say that yes, judges need to be gender trained, need to be more empathetic towards women, etc. But there are also often many cases where women are also making mistakes. They use 498A where it doesn't need to be used.
Absolutely.
Where the question of disabled children come in, where the question of children with special needs, not just disabled children, come in. The role of the mother and father post a divorce. How does a child actually, you can't divide, child is a human being. Even if you give joint custody, the parents have to be on good enough terms. Otherwise, the poor child is the one who gets, the brunt of whatever may be the hostility between parents.
Right.
All of this is a very, very difficult, they're very difficult, areas or terrains for just one judge to be able to do it.
And as Mr. Wilson, Lalitha ji said that even lawyers have to be empathetic, but on this same note, she also appreciated you for your approach. But on that note, let's take a few questions from audience here. Please go ahead, introduce yourself and speak your mind.
As Lalitha ma'am said about the issue of ego, that both husband and wife are having their income and they are having ego clashes also. So, sir, what is the difference or what benefits we are having after this act? Because as ma'am said, 11 lakhs case are pending.
All right, so let's take that question to the male panelists here. Sir.
I think the entire intention and object I said earlier is to bring conciliation and settlement of the disputes so far as the family matters are concerned. We have seen as nearly as 713 courts, I believe, throughout India, the family courts have been established. Originally, the civil courts were given jurisdiction of granting divorce, passing case orders relating to maintenance, custody of child and all. And after this act was introduced in 1984, the entire thing has been shifted to the family courts. I believe that the court, this Family Courts Act 1984 and the family courts have certainly brought a breakthrough so far as the family settlement of family disputes are concerned. There are special courts notified, and every districts, if you have a 1 million population, the courts are established, and the family courts are functioning very well. There's no difficulty about that. All that, you should bring a life into this act. That's what Madam Lalita was saying. I do agree. What she wanted to say is the lawyers should be more empathetic. You need not, confine yourself with the judges.
Right.
I do agree. The lawyers who handle this family court cases, certainly they should also be trained. They should not see this as any other case like a property dispute or a check bouncing case or something else. They should also, approach this with a more emphatic and more considerate. They should spend more time on this. The High Court, the time has come now. The High Court should have a separate portfolio judge.
Right.
So far as the matters arising from the family courts, to hear the matters exclusively and decide. Take, for example, a case of divorce. In the family court itself, it takes about 5 years, and another 5 to 10 years in the High Court. By the time it reaches Supreme Court, already 20 years have gone. The important aspects in the life is somewhere about 20 to 30, 35. So all your young age is being spent only in the courts. So we have to think in those lines, how to dispose of these cases. The only way is to have more number of courts, more number of the judges. Fast track courts also can be brought in. We can even request the High Court to have a separate portfolio. And above all, I have been enunciating about the regional benches of Supreme Court.
Right.
The benches of Supreme Court should come in every region. I have said, I have even brought a private member bill.
Sir, I have a question. Why there was no legal authority given to these two states, Nagaland and the Himachal Pradesh?
This is a bureaucrat's mistake.
Yes.
They have notified in 24 states, and 2 states alone they have not notified it. And by the time the state of Nagaland and as well as this Himachal Pradesh, they have brought in the family courts in 2019 and 2008.
Yes,
so
sir.
this was later on, they came to know only when a litigation came to be filed before the High Courts.
So my question is regarding the parent legislation. So in section 4 of the act, which talks about appointment of judges, it is mentioned that preference is to be given to women. So I just want to know the intention of the legislature behind this provision.
Dr. DESWAL.
We generally presume that maybe women, they are more empathetic towards the cause of family matters. See, because it is like women, they are the ones who make greater contribution towards the families. So that was the basic objective when they said that we need women judges as the presiding officers in family courts. But that is something which is just to be preferred. It is not the rule. We have so many feminist male judges also who are doing an excellent job across the country. So there is no such thing that it is only women judges who could be more empathetic towards the cause of women, other men, children, because it is generally presumed that women, they are the homemakers. But see, in contemporary times, you cannot expect every woman to be making sacrifices.
Right.
When it comes to these family disputes, if she wants to do, it is her own call, but you can't compel her to be a superwoman.
True.
So it is something that we all need to understand. And moreover, there is one more point that I would like to highlight here, KRITI, and that is a very beautiful observation by Justice Chandrachud recently when he said that the typical definition of family, it has been undergoing a change
Absolutely.
now.
Absolutely.
Wherein the manifestations of love, they might not be typical, but they are real. So the Family Courts Act, although they have been amended recently, but I think that our judges, they need to be sensitized and they need to take into consideration those cases also which do not fit into this typical definition of family, that is a heterosexual relationship
Absolutely.
with children, which is a permanent institution. So there could be step-parents, there could be same-sex partners. So this expanding definition of family also, it needs to be covered within this law.
And as Lalitha ma'am also said that there are many grey areas and human relations cannot be objectified. Let's take another
Absolutely.
question on that note.
There are the family matters regarding the personal issues. So what are the court approaches regarding the mediation?
Look, every court, the approach is very simple. To see as far as possible if the partners could reconcile and the marriage be saved. That's what is stated in I think the first lines of the act itself. That's why these family courts have been set up. But times are changing today. So we often see that there are cases where perhaps if reconciliation is not possible, it is best for the divorce to go through, but as amicably as possible. What happened 30 years ago or what happened 20 years ago may not hold true today. Society has changed, relationships have changed, the components in a relationship have changed. Earlier, women used to be chiefly homemakers. Today, many women work and are homemakers.
Right.
Parents, both men and women, have different pressures on them nowadays. And if you come from a different generation, you will see there's a huge generational change in the way people look even at a marriage.
Absolutely.
It's not just about same-sex marriages or divorce and step-parents, etc. It's also about the institution of marriage itself is looked at very differently today. Earlier, the sense of partnership that was there was based on different rules. Today, the partnership is, again, the set of rules seems to have changed. Neither is wrong. As times change, people also change along with it.
As you stated, women is the homemaker. But sometimes, is it not like that women are afraid to have a divorce, even they having a fight?
Definitely, because of the stigma that is attached. And see, we say that I have a freedom of choice. It's my choice whether I want to work or not. But the truth is that women, they exercise their freedom of choice also in coerced surroundings. Sometimes I might be coerced by the love and affection of my family members.
Right.
So it is not that it's a totally free call for me. And women being homemakers, it is something which is again a very patriarchal, traditional notion. And that is the reason why when we opted for these family courts mediated settlements, that was because we believed that whenever we talk about conciliation at home, usually there would be a pressure on the woman to adjust. She would always be compelled that, see, you are the one, it is upon you. The main responsibility lies to ensure that the family fabric is preserved intact.
The Family Courts Act puts an emphasis on using conciliation and settlement and counseling as a method to resolve the issues. But we find that more often than not, these conciliators who are actually helping the parties, they tend to change quite a lot in shorter time periods, and that means that it shakes some confidence that the people would have in the conciliators, because they have to retell their stories to numerous people and continually. Right. And then, as Sir said, they have to face, getting a divorce or something takes about 5 years.
That whether there is any mechanism to fix accountability for such officers so that such mistakes cannot be happen in the nearest.
Even the family court, judge or the authorities who are dealing with these types of conciliation, they should take into consideration that the counselors should not be, changed frequently. Sir, so far as the
fixing accountability,
yes. Latches is concerned, certainly, the concerned bureaucrats should be set accountable.
Lalitha ji, I have last 40 seconds on the show for your closing comments.
Yeah, what I also wanted to say was that, we need many more family courts. First of all, we also, to an extent, need more judicial accountability. This has become a huge question on many issues that people are facing, not just in family courts. Accountability in a family court has to also extend to the bureaucrats who are supposed to be helping in actually the dispensation of justice to, couples who come to the family court.
The Family Courts Act, it is expected to be preservative rather than punitive to family and marriage. On that note, thank you so much for joining us, Mr. Wilson, Dr. DESWAL and Lalitha ji. Well, viewers, that's all we have for you in this edition. Thanks for watching and stay tuned to Sansad TV. Namaskar.